Good afternoon, my name is Shannon Wood. I'm with the Woodward-Ahupua'a Alliance, and I was not intending to testify today. I have submitted written comments on the rules, primarily the section, the first chapter, dealing with the, how to run the organization as opposed to the more specific things. However, I am very disturbed over not only what happened at the public hearings that you conducted, but at the governor's meeting last night, and also some of the comments that have been made today. You people are highly qualified. Mr. Isla is a long-term employee of the Department of Land and Natural Resources prior to becoming the head of the Department of Land and Natural Resources. Mr. Young is the head of Budget and Finance, and that means that he knows how to count pennies. Ms. Evans, I first met her when she was with DAGS, if I'm not mistaken, and now she's Deputy Director of the Department of Business, Economic Development, and Tourism. Mr. Bunda, who isn't here today, is a former state senator and in fact was president of the Senate. He understands the political processes. Mr. Cariso is a major business owner. And we do have something in common, which is we both are very strong fans of the San Francisco Giants. But my point is that we have highly qualified people sitting on this board who are working for either long-term state employees or they have professional qualifications, and I appreciate that you're here. Secondly, the information about repealing Act 55 in 2011 can only be done by the state legislature. The governor can't repeal it. Now, he can indirectly screw you guys by not releasing any funding to pay Mr. Haraguchi's salary, but he can't repeal it. The public can't repeal it. We do not have initiative at the state level in order to draft, to put that through. So the only alternative is to talk to the people who are on the ballot in the general election ballot and find out where they are, and then go down to the legislature after the election and start working on this. But you can't repeal yourself. The governor can't repeal you folks. So please take into consideration how things get worked out. If you don't like that situation, then go fight for putting a constitutional amendment in the Hawaii State Constitution allowing initiative. But right now we don't have that. The other issue that I'm very disturbed about with respect to is that the need to be able to understand the rules are not, the proposed administrative rules are not set in stone. They are the first draft, and I appreciate the fact that you folks went out there, but we have to be able to expect that something be done, and that comes through a process, which is public hearing, looking at the recommendations, bringing them back for discussion and so forth, and I really truly appreciate that. I probably wasn't even born before when the Department of Land and Natural Resources was established, but I'm sure that 50, 60 years ago they probably went through the same process, and so did all of these other authorities, commissions, boards, etc. went through the same process. And I appreciate the fact that you folks have really had to take a lot of crap from people who were throwing it at you without understanding how the process works. Thank you.
Questions? Thank you.
Allison Long? No? That's it. You want to testify on the rules? Okay.
Thank you. She raised her hand. Go.
No. I didn't sign up. Can I testify?
You can come and sign up.
Okay.
Go ahead, Drew. Go.
again, I think it goes back to the same public perception of how things are gonna get done. The discussion was that only about 10% of people were within the box of what is in accordance with the law. That public hearings were only going to be on the administrative rules, and anything that is spoken or written or sung out of that little box appear to not be considered. And I think that goes against the very basic premise of the PLDC administrative rules. Because one of the biggest phrases that were consistently being used was that it would display cultural sensitivity. Now, I can submit to you that a lot of them did look at the rules, and the rules were so ornery, the rules were so off the cuff, that they refused to play the game. And also, a lot of that 90% were talking about culture. And so, in order for the PLDC to even have an ounce of sensitivity to culture, that ought to be included, for goodness sakes. You know, it ought to be included because so much of it was that. And of course, personally, as a private property owner, I was totally floored that so much effort had been put into drafting that rules, and yet one of the very basic tenet of private property rights in our democratic society is private property rights. But the rules there stated that a private property owner who lives adjacent or abutting a possible PLDC project can be compelled to pay for infrastructures. I mean, that's right there, black and white. There's no misinformation about that. There's no misunderstanding about that. So things like that is very, very jarring to people who are usually very reasonable, because it is very offensive and it is very, very, what's the word? I mean, it's very, very autocratic to say that, hey, I am the big PLDC, and these are the rules that we have, and part of it is that we are going to do what we want, and that we're going to go to the point of crossing that line of demarcation that we will not respect private property rights, because we, the big government, has the right to compel you to do things our way. And that, to me, is a very, very troublesome foundation flaw, because private property rights is a very integral part of free enterprise. And I'm not going to go on and on because there are so many things wrong with that rules. But to me, I think the most important at this point is that although 10% stayed within the box, within the conformance to the law box, 90% refused to play the game, and 90% was where all the cultural sensitivity that a PLC is supposed to have. Thank you.
Donna Wong, Executive Director of Hawaii Housing Friends. I was curious to know what Mr. Haraguchi meant by substantial testimony. What does that mean? One testimony that's substantial, or what is that guideline that he's going to be evaluating that's going to be substantial, that will lead him to recommend that the rules be changed or not be changed? I think that's important to know. There needs to be the threshold.
Did you say substantial?
Well,
I
no,
think
changes to the rules.
substantial changes to the rules.
Well, but it,
Not substantial testimony, substantial changes to the.
okay, but it comes from the testimony, right?
It's,
Those changes, whether you
Yes, it will
see
come
that
from
there's substantial recommendations or changes needed,
Right.
and that comes from the testimony.
Yes, it comes from testimony.
Right, so what is that threshold? If you've already said only 10% of the population spoke to the rules,
Well,
then,
The term substantial has
Yeah.
been defined by
Right.
case law, and generally it refers to if there's changes to the rules that were not based on comments made during public hearings, then those are substantial changes that require that the rules go back out for public hearing. So that's a term of law that has been interpreted by the courts.
so, can you say that again? So they're gonna discount the 90%?
No, basically
Because
it's, if there are changes that are suggested to be made to the rules that went out for public hearing, and those changes were not based on comments received from the public during public testimony or through written testimony, then those changes are considered to be substantive changes which would require further public hearing.
Okay, so that includes what was said during the public hearings and the written comments?
right, yeah.
Okay. And when we were responding to the draft rules, the strategic plan had not even come out. We didn't have a copy of that. So is that going to be incorporated into the rules, or it stands alone? Because if you're replying to rules, we look at it and want to do it in a comprehensive manner.
yes.
And that was not even mentioned, so I think that that's a big omission if you're going to have a strategic plan as a component.
We will, that's that's the stage that we're in at this particular time. You know, we're looking at the rules, we're looking at what you have before you, the strategic plan, and try to marry both, so, you know, it's in balance, yes.
Well, then that might meet the threshold for substantial change because the strategic plan was not out at the time
Ms. Wong,
comments were due.
You do understand, we did not create the strategic plan.
I understand that. But if you're not going to incorporate it, fine. But if you are, then
And
it
that's
needs
why,
to be.
I think that's why some of the discussion is, we acknowledge you are correct, right? It creates, which comes first, chicken or the egg? But we ultimately, I think the board wants to make sure everything is, at least fits together, it's a nice, good fit. So that's why I think it does warrant, we take some time to digest, study the strategic plan. We don't really know what the substantive changes to the rules will be, if they will still be in concert with the strategic plan. That's why I think, as I think this board has done for the last year, in terms of the rules process, been very deliberate not to rush to get anything completed so that we can make sure everything is in concert. So that's why, I'm just acknowledging your statements and agreeing with you that yes.
Yeah, we agree with what you said.
Okay, okay. One, okay, thank you.
If I can, just remember the result, however, if there is substantive change, that has to go back out for public hearing. So that's really what it is. Yeah, we commit to that.
Okay, thank you.
Right, so is there any written testimony on this item?
We received something from Mr. Shiroma, but again, it came right before the board meeting, so I hadn't been able to look at it, but I'll look at it, and so I don't know if it specifically applies or to what.
We'll note that we did receive written testimony from Mr. Shiroma.
Right.
Regardless of what the item is.
Yeah, and he wanted it to be made part of the minutes. That was his instruction.
We will
reflect
we will
in the
reflect.
minutes that we received written testimony from Mr. Shiroma, like other people that have submitted testimony
All
here
right.
today as well.
Thank you.
Okay, any other questions on this items, directors?